Welcome. Today we're going to talk about mandatory arbitration and arbitration programs. My name is Sam Lillard, and I'm an attorney with the law firm of Fisher and Phillips, and we also have on the presentation Matt Parker. We're both partners with the firm in our Columbus office. We have been working with clients who have been having these programs. Some have had these programs for many, many years. Some have just got into creating a mandatory arbitration program. And my observations, having done a lot of arbitrations now, is that they are successful if, one, you have a good arbitration agreement, meaning that the terms are appropriate and thought through. Two, you've selected a good vendor, and by vendor I mean a company that assists you with the arbitration process. And, there's American Arbitration Association, or the one that we're often using these days is NAM. But if you have a good vendor, there's some poor vendors out there I wouldn't recommend, and if you have them, they can create a problem with your program. And then you need to have a relationship with an attorney or a law firm that is familiar with arbitration and how to use them to become, use them efficiently and take advantage of the cost savings that are attributed to them, right? So good agreement, good vendor, and good relationship with a law firm that knows how to use arbitration and understands its speed and efficiency. We'll talk a little bit more about the pros and cons on that, but let me, kind of walk back a little bit about why, I have been practicing law for 30 years, and most of my practice is involved employment litigation. And I've been living and breathing, dealing with employment disputes in court since my career started. I originally was hostile to the idea of arbitration, and this is going back 10 years ago. I was thinking, we often have a litigation dispute about whether you can arbitrate in the first place, and there were some goofy things that were going on at the time, and there was law challenges, and so I thought, why even do it if you're going to have to litigate? That's changed, and my attitude has drastically changed. In fact, I'm now one of the big proponents of arbitration. In fact, I can tell you, if I was a CEO of your company and I had a decent sophisticated HR person, good record-keeping processes, and knew a group of attorneys that were familiar with arbitration, I would be a no-brainer. I think it's just a better mousetrap in this environment. So what is the environment? Well, going back, I go back all the way to the Civil Rights Act of 1991, and since that act was passed, which gave employees the right to have a jury trial, and punitive damages were allowed, I've seen an increase each year in litigation in the employment setting. In fact, I think I've seen the figures over the last decade. Charges or EEOC filings for under Title VII have increased 700%, and it just keeps ticking up. In fact, I usually try to look at the claims filed with the EEOC each year. What is the number one type of claim? This graph shows you that, interesting enough, the now number one claim filed against employers in this country with the EEOC is claims for retaliation. And that's claims where someone said, hey, I complained about some type of discrimination, and regardless of whether that was true or not, they then did something bad to me in retaliation for me complaining about it. And that is now the number one cause of action. And the reason for that, and Matt and I are very aware of why that is, the reason it's number one is because it's very easy to allege and really hard to knock out of court on summary judgment. All you have to show is that you engage in some protected activity, that something bad happened to you, terminated, discipline, reduction in pay, some adverse employment action, and then you have to just allege some causal connection between the two, and voila. And so it's a real easy claim to allege, a difficult one to get tossed out on summary judgment and increases the likelihood of trial. So a lot of the plaintiffs' bar are filing those left and right now. Used to be race discrimination was the number one. It's still pretty prevalent. And during this pandemic of 2020, what would you expect? Litigation dropped in the employment world. Yeah, partly because a lot of employers laid off employees. We had a smaller workforce. People were worried about maintaining their position, so less likely to rock the boat with litigation. And although there was an uptick in what we call COVID litigation, in New York, California, and interestingly also in Ohio, we've had a downturn in the amount of litigation last year based on the pandemic. However, what was interesting is in November of 2020, we started to see an uptick in cases filed. And that trend has continued since. And unfortunately, because I think the economy now is going to, we're predicting it may boom or explode. We expect also a explosion of litigation in 2021, somewhere in the summer and later in the year. And there's also been a lot of pin-up issues that I think are to come to head in 2021 that weren't raised in 2020. So, again, the picture is litigation in the employment areas seems to continue to increase, and whole industries, legal industries, have been created really to transfer wealth between employers and employees. And, and of course, it's been interesting in my career over these 30 years to note that, a lot of our social engineering in the United States is done through the employee context. Title IX, the Americans Disabilities Act, Family Medical Leave Act. We're talking about creating mandatory leave, transgender rights, all those issues, those struggles in changing our society are occurring in the context of employment litigation, which is one of the reasons to drive up litigation. I should mention my colleague Matt, who's on this call and is going to present in a few minutes, also is probably one of the better defense counsel in this part of the country involving class action wage and hour litigation. And we've also seen a large rise in that type of litigation. The cost associated with those are really huge. Those are if we would talk about viruses and litigation as a virus, these would be the serious illnesses that are out there floating around that can land upon employers. Class action wage and hour cases can be very, very expensive, very complicated, and interesting enough, as we'll tell you here, a mandatory arbitration can bar those to some degree. So that's another interesting aspect of it. So we've had a steady increase over the years in litigation, and there doesn't appear to be any change in sight. And what are the other concerns about litigation as a vehicle, traditional litigation as a vehicle for resolving employment disputes? Well, in this slide, there are two major concerns that I've always had in working with clients in resolving disputes in traditional litigation. What do I mean by traditional litigation? Litigation that's filed in state court or in federal court. One, it takes a long time to resolve these disputes. Now, as an employer representing employers, as an attorney representing employers, what we're trying to do is resolve cases at the earliest opportunity with the least amount of cost. And unfortunately, the other side is trying to get to trial. And the time process where there's a complaint, an answer, a discovery phase, then we always typically file a motion to the judge saying, please judge, based on the discovery, we think there's no case, no legitimate dispute about the facts, throw the case out. And if we're not successful, then there's trial preparation. The time it takes from that complaint to a trial or a summary judgment can easily be 18 months. On average, that's about right. Even a quick litigation in state court is probably about an 8-month process at the quick end. On the long end, it can be 2 years. and it's not unheard of to have 3. And I hate to say it, I've been involved in 2 cases that have taken 8 years because tenacious plaintiff, multiple appeals, complex legal issues. That's rare, but this is not a short process. And unfortunately, because it's not a short process, the other drawback of traditional litigation in state or federal in court is it's just really expensive, even if you beat the plaintiff. The defense costs on average, and I'm talking, when I use these numbers, I'm talking about these numbers in the Midwest, which is a pretty conservative area. The defense cost to employers can easily be, on average, $120,000. Now, again, is trying to resolve disputes at the earliest opportunity with least amount of cost. And, the low end can be 60, with the high end can be 250 plus in your defense costs alone. Now, of course, those numbers compel a lot of employers to quickly sit down with the plaintiff and settle the cases, even though they don't think even if they think they're not meritorious. So traditional litigation, it can be complex, it can take a long time, and it can be just expensive even if you win. And that is a problem. So, there has been for quite a while an interest in alternative ways to resolve in employment disputes. Now, again, I've been around long enough to know what the climate was prior to 1991, and that was a time period where in federal courts you really you didn't get a jury trial for employment disputes. It was often just addressed to a judge, and really the only remedy that was at stake is reinstatement and back pay. That has changed since the Civil Rights Act of 1991 and has created an entire new industry. Good or bad. I will say, just to be intellectually as honest as I can, there has been a lot of societal good, I think, based on this back and forth, but it's been on the backs of, some employers in terms of managing the expense of raising complex issues under the Americans with Disabilities, Family Medical Act, the Me Too movement, sexual harassment. The outcomes of those, I think, have been positive, but they've been very expensive and disruptive to getting work done, right? So arbitration, what is arbitration? Well, it's a private dispute resolution program, and I emphasize the word private. It's not public. That's one of the great benefits of it. It's a private dispute resolution process where you, the employer, get to select the rules that apply within reason, right? The parties to a mandatory arbitration have agreed not to pursue court action, so any disputes go into an arbitration. It uses typically a private arbitrator who acts as the judge in the case. It's usually one, but you can create a situation, if you wish, to have 3. Don't recommend that, but you can. Some of the older arbitrations would have a panel of 3 arbitrators. There's no jury. The decisions, unless you choose to do so otherwise, are final and binding. They're fully enforceable in court, and they have limited to no appeals. Again, you get to choose whether you want an appeal or not. We usually recommend you don't. And I'm going to turn it over to Matt here to talk about the law change that have really opened up mandatory arbitration programs as a very viable option for employers.
Sure. Thanks, Sam. So we'll start with the Federal Arbitration Act, which was basically a federal law enacted back in 1925. So it's a pretty old one, providing that courts will facilitate private dispute resolution through arbitration. So basically, even though we have a judicial system, the FAA, when it was enacted, created a national policy in favor of arbitration. And since the time that it was passed, the case law that's developed around it has largely resolved any doubts as to whether an issue can be subject to arbitration. They've resolved it largely in favor of requiring the parties to arbitrate when they have an agreement to handle their disputes in that manner. And in the past several years, there's been a lot of movement. There have been some trends on the state level to try to curtail arbitration, but ultimately, most of the federal courts that are handling those state statutes have found that they're preempted by the federal act, meaning that to the extent that any of those laws are inconsistent with the FAA, they're not going to be enforceable to displace an otherwise valid arbitration agreement. And we've seen, I think, as recently as 2019, and I think there have been some grumblings about it with the current Congress, but there have been some movements to try to limit arbitration for certain types of disputes, but so far, none of those have been successful. And when parties agree to arbitration, the law of the land right now is that that's how they're going to be required to resolve their disputes. And the consideration by employers for arbitrating disputes has recently increased in the wake of a decision, Epic Systems versus Lewis, which came down just a couple of years ago. And Sam, I think you could skip this forward. Yeah, so basically for nearly almost 80 years, the Federal Arbitration Act and the National Labor Relations Act peacefully coexisted, and nobody found anything to be incompatible between them. But then in 2012, for the first time, the National Labor Relations Board made an announcement in a decision that a class action waiver contained in an arbitration agreement would violate Section 7 of the NLRA, which allows for and protects concerted protected activity among employees. Most federal courts to consider that issue after the 2012 NLRB decision disregarded it, but there were a few that latched onto it, which created a circuit split. And so then the issue was eventually found itself before the Supreme Court of the United States. Sam, you can skip. So when the Supreme Court addressed it in a 5-4 decision, they upheld the validity of class action waivers under the FAA. And this was a very big win for employers because this commonly came up in the context of a class and collective action for unpaid wages under the Fair Labor Standards Act, or even under state law. So the fact that employers could require employees to waive any rights to bring a collective action and instead have to pursue any sort of action on an individual basis was a big win for employers that just lessened the potential scope of liability from something that could be statewide or even nationwide in scope to something that's just on an individual basis. But the Supreme Court decision in the Epic case reinforced the notion that the FAA shows that there's a national policy in favor of arbitration, and that arbitration agreements would be enforced according to their terms. The decision did not impact any issues that might be handled, just almost exclusively by state law, which typically just go to the validity of the formation of the contract. And where we most often see this come up, Sam, if you want to skip ahead to the next, is what's called consideration, which is an exchange of promises for an agreement. And it's going to be handled differently when it comes to a new employee versus an existing employee. For a new employee, simply offering the individual employment in exchange for them entering into an arbitration agreement is sufficient to support that agreement. The real wrinkle comes when you're dealing with existing employees, and it will depend on which state you're in. In most states, you can offer an employee continue their employment in exchange, but there are a minority of states out there that require you to offer them something additional of value. So maybe a spot bonus if they would agree to enter into it, or maybe an extra day of vacation. So that's really going to depend on which state you're in. But again, when it comes to existing employees, a majority of states are going to allow the offer of continued employment to be sufficient to support that arbitration agreement.
Yeah. Oh, is that? I'm sorry. Were you?
Back to you.
Okay. Yeah. So again, my attitude toward arbitration was skeptical prior to the Epic System Lewis case, because again, there was a lot of plaintiffs' attorneys don't like arbitration. It messes up their financial incentives for bringing the litigation, be blunt with you, and other reasons. So they would try to get out of it, and there was arguments that they could make and create litigation to even get to arbitration. The Supreme Court in that Epic System case got rid of that. And, after that case, I was watching to see whether there'd be any successes in stopping the trend to move into arbitration for employment disputes. Some states were saying, hey, because it's private, we're not going to have public newspaper articles about sexual harassment cases. So, that's a problem, and they would pass legislation. The federal courts have thrown those out because of the preemption of the Federal Arbitration Agreement Act, and courts have been very strong in enforcing appropriate arbitration agreements. Again, really the only attacks these days are the old-fashioned contract attacks that there's not consideration, or it's unconscionable, or the employer waived it, or there was fraud or duress. As long as you handle those things, which are typical contract issues, the courts are very enthusiastic about enforcing arbitration cases for employers. And as Matt indicated, continued employment is sufficient consideration for such a contract in Ohio and in a lot of Midwest states. There are a few exceptions, so you may have to add something of value. It doesn't have to be much to to have someone sign a contract outside those states. The only outlier is a little tricky. Everything seems to be a little trickier in California. So if you have large California operations, then there are some special things that need to be reviewed and thought about. But New York tried to slow it down and wasn't successful. So what are this is the money slide. Let's talk about the pros and cons. And some of my colleagues are a little more cautious on talking about the pros, but I have observed this now for the last 4 years. I'm very familiar with arbitration almost for 2 decades, and I can tell you that this seems to be, as long as you have a sophisticated HR person able to have pretty decent record-keeping processes and onboarding, this is just a better mousetrap. So what are the pros? Well, it is typically on average cheaper than your defense costs. That's not true of every case. There can be an outlier on that. But instead of seeing $120,000 in a defense cost, if you have a counsel that know how to manage the efficiencies of it, it can be $20,000 to $40,000. Still a lot of money, but it's a whole lot cheaper than $120,000 in defense costs. It's also a lot quicker. Again, it's not true in every case, but on average, I just see quicker resolutions. These cases should be resolved within 3 to 8 months, if not earlier. I mean, I try to get these things resolved within 3 months. And again, some of my colleagues are not as comfortable with the speed of it, but it is built for speed. It's an issue, dispute, a selection, a hearing, and you're done. and you're done. The good news is you can select the arbitrator. Now, this is a really big pro because in litigation, whether you're in state court or federal courts are pretty sophisticated. In state court, you never necessarily know what you're going to get. Some judges are very good with criminal matters and have very little clue as to employment issues, which can be very complex in this day and age, right? So you may get, and some judges are very experienced with that. It just really depends. So it's a hit or miss. The nice thing about arbitration is you can select and create a program where you get only experienced arbitrators. You could say you will only accept arbitrators that have 10 years of employment law experience. And when you create that in your agreement, you actually tend to get employment defense attorneys who are acting as arbitrators to resolve these issues. And these are individuals that are conservative and are very knowledgeable about employment issues. And that is one of the great benefits, I think, in arbitration. You get quality arbitrators. Again, you have to pick the right vendor, you have to have the right agreement, have the terms in that agreement to do that, but that's what you get. It is also, and this is one of the number one reasons a lot of our clients have adopted arbitration programs, it's confidential, right? In a lot of employment litigation, you get a lawsuit and they drop that lawsuit off at the newspaper and it gets published and there's a lot of media and that causes a lot of headaches and disruption to the workplace and the top of the litigation. With the nice thing about arbitration, it is a private setting. It is often not public. The outcomes aren't public. There's not an industry out there that's tracking the litigation that's filed against employers because it's filed in arbitration in private. That is the number one thing. Now, because it is confidential, some states were trying to say you can't have arbitration for sexual harassment cases because then we won't know whether you're having that issue in your workplace. Those have been not successful because, again, the Federal Arbitration Act preempts state law, and most courts favor arbitration agreements if they're done right. The other aspect is we get much more conservative verdicts. We don't seem to have a problem with runaway, you can have a problem with runaway verdicts or runaway jurors in some parts of this country and in some courts. You don't see that. You see a very conservative verdicts because you're dealing with a experienced employment attorney who often understands the dispute between two parties, and et cetera. So the verdicts are more conservative. And they're also final, right? A lot of problems, we may go through, we may get a charge of discrimination and we get no probable cause and everybody's happy, and then they file a lawsuit in federal court, and we go through that whole lawsuit and we file for summary judgment. The judge grants it in total, and we're happy because we won. Then the plaintiff's counsel files an appeal. It goes to a court of appeals. It takes another year. It could go back to state court. So the nice thing with arbitration is the way, if you set it up this way, because you can choose that, it's once the decision is complete, it's done and over. So it's final. There's no appeal unless you write one in. You don't have to. In fact, I don't recommend it. I say have a hearing, address it to the arbitrator, they'll make a decision, and then everybody's done and we move on and back to work, right? The other great news is you get to write the rules within reason of what you want. So, and one thing I didn't have in this column that I know Matt is very aware of, you can include in your arbitration program a waiver of class action wage and hour litigation. That is huge. In fact, the two big things I think for employer that really is interesting to them is the confidential proceeding, the conservative arbitrators, and the fact that you can include a class action wage and hour litigation waiver in as part of this agreement. So I would conclude my observations over the last 4 years since the EPIC has come out on arbitration and private employers who have been using and our experience in implementing arbitration programs is that they tend to be cheaper, they tend to be faster. They actually, by just having them, they seem to put a wet blanket on litigation in general. Because we often encourage you to have a built-in mediation program that does resolve some of the stupid stuff. And it prevents runaway verdicts. And again, you can waive class action liability. So there are cons, right? And the cons are that to have an enforceable arbitration program, the employer has to pay the costs of that program. Meaning that you got to pay the filing fee with the arbitration vendor, and you have to pay the arbitrator's cost. You can add a provision where the employee has to pay an amount equal to a local filing fee, and we encourage you to do that so that they have just some stake in the game. But in order to have this program, you've got to pay the cost. But overall, costs are going to be a little cheaper than they would be. In fact, they may be significantly cheaper than they would in litigation. In not every case, but that's what I've been seeing for the last 4 years. But you have to pay the upfront fees. Some of the arbitration vendors say, I want a $750 arbitration fee, and then you got to pay the arbitrator's rate, and that can be, up to $15,000, $16,000, $17,000, or $18,000, right? But overall, the costs are less. You also have less discovery time. That is to find out facts from the other side. Now, of course, that means that they also have less discovery time. One of the big explosions in litigation over the last 10 years has been just the extreme cost to employers of having to deal with electronic discovery. You can keep that very limited to almost non-existent in arbitration, right? So we don't have to go through every record, every email prior to having a hearing on arbitration. So it's a lot less discovery time. That's both a positive and a negative. But, again, in the employer side, we often have all the records. We often have a lot of the witnesses at our disposal to deal with these issues. There is also a criticism that arbitration can tend to split the baby. You have an arbitrator, he has two sides, tries to make a compromise to resolve it. That is still concerned if you pick the wrong vendor and if you don't have good language on the experience of the arbitrator. But I'm not as concerned about that anymore. And even if with some of those concerns, the splitting the baby, actually the baby is a whole lot smaller. Probably not the right analogy, but it's a lot less to split in arbitration, right? Kind of reminds me of going back to the days of the Civil Rights Act of 1991, prior to that act, where litigation was about, was there a dispute, reinstatement, back pay. You can have, one of the cons is you can't have pre-arbitration litigation where someone says, no, I signed this arbitration agreement, but there was fraud involved, therefore it's not valid, or this arbitration agreement isn't valid because there's no consideration, or it's too one-sided, or a number of other issues to try to get out of it. You can have some pre-complaint arbitration. Our involvement in the last 4 years with the Epic decision from the Supreme Court, we've been very, very successful in enforcing appropriate arbitration agreements in court, and that's no longer a concern. We see some attempts to struggle, but most plaintiffs' counsel realize, boy, it's a tough road to hoe now based on the case law. There has been a concern that if it's not done right, it can encourage some minor claims, that because it's easier to raise a dispute, you may have employees raise junk complaints. We recommend in an arbitration agreement you have a built-in mediation. That seems to kill all that stuff. And I really haven't seen examples of employees saying, great, we got an arbitration program, I'm going to use it for every time I don't get a job or a promotion. I'm just not seeing that, but that has been a negative that's out there. It's possible that you could have your employees just initiate your arbitration program all the time. We're just not seeing that in reality. There is a class action problem. Again, there's large law firms that look for class action wage hour litigation. to bring. And when that happens, and they find out there's an arbitration program with a waiver, they will try to manipulate system by saying we've got 20 clients that are your employees and we're going to bring an arbitration in every case. That means you have to pay the filing fee in every case and the arbitrator in every case. But if that's happening, and I think Matt can comment on this too, but if that's happening, still going to be a lot less than having a class action wage and hour case in federal court or in state court. But there's not an easy way to manage that because they could still cause you some trouble if they know what they're doing. But for some of the other, less sophisticated wage hour plaintiffs' attorneys, we're just seeing that they stay away from cases that have arbitration in it. Not always, but again, having the program itself seems to put a wet blanket on class action litigation and litigation in general. Again, there's an exception to every one of these comments I'm making, but that's generally what we are seeing at this time. The other con, and it can also be a positive, is it's final. You have a hearing, he makes a decision, the arbitrator or she makes a decision, and it's done. No appeal, unless you want to write that into the rules yourself. And I've had some discussion with clients about, yeah, we'd like an appeal process, but you get to create that if you want to. I don't recommend it. I think the nice thing about arbitration is there's a dispute, you set up an arbitrator, everybody shows up for a one-day hearing, you get it done, there's a decision, and we move on, right? Look, arbitration doesn't prevent harm to you as an employer if something has gone wrong and it's your fault. It doesn't. You'll still be taken to task. I would suggest it'll be a little lighter on you than it would be in state or federal court, but still, you could be taken to task by an arbitrator just as well as you can with the judge if you've created a problem and you're at fault. But for those other situations, I think it's just a no-brainer, again, if you have these elements. One, you have a sophisticated HR person, and what I mean by sophisticated is really just some experience. Two, you have good employee onboarding processes and ability to pretty good record-keeping processes. And three, you understand the value of arbitration. If you don't understand it, then you probably aren't ready yet to have such a program for yourself. But if you do have those three, this is to me, a no-brainer in our modern society. Do you have anything you wanted to add to that, Matt, on class action?
No, I mean, I think you're right. The biggest risk is if you have plaintiffs' attorneys that are out there trolling for people to join the potential action against the employer, you can find yourself in a position where they're filing multiple demands for arbitration. But at the end of the day, if you have the class action waiver, you're still, that's still going to save you from, potentially, if you're in a lawsuit, the court forcing you to hand over actual contact information for all of those individuals, sending out notice of the lawsuit to them, and you're going to get a lot more, people joining a lawsuit like that. So, again, as frustrating as it can be to have those, potential arbitrations stacking up, you're still looking at a scope that is significantly less than what you might be facing if you're, in court. And, and I can think of it where I've had it recently happen. Had we been in court, we could have been dealing with notice of a lawsuit going out to around 4,000 or 5,000 potential individuals. And, you might have typical rates is that maybe 20 to 30% of them might join the case, which is a lot, but we had arbitration agreements with class action waivers. So the plaintiffs didn't get that contact information. The court didn't send out notice of the lawsuit. And instead of dealing with the claims of close to 1,000 employees, we were dealing with claims of maybe 20 to 25. So frustrating to be dealing with that many demands for arbitration, but a fraction of the potential liability. And the only other thing that I would think of, and I don't know if it's a pro or a con, but we usually tell people when they're considering arbitration agreements, if you have a business operating liability insurance policy that covers any employment disputes or employment practices liability policy, just to check with your carrier to make sure that they would cover arbitration in the same way under the policy. Chances are, because of all these benefits, they do. And anytime I know the issues always come up where there is insurance coverage, they've treated arbitration is almost the same for coverage purposes. So I wouldn't expect that to be any sort of issue here, but certainly, one thing to run by your broker, to make sure.
Yeah, and in fact, a number of our clients who have opted in on arbitration programs have checked with their, we call them EPLI carriers, employment liability insurance carriers. And, this is another option employers use to limit their liability. They insure themselves for employment disputes. And unfortunately, although you can get insurance for class action wage and hour litigation, it's very expensive. You can't get it, but most employers don't. It's often carved out. But, talking to the major carriers out there, they like arbitration, and I've not had any issues on them just including the coverage in it. A lot of the agreements include it now, I'm seeing, because, they understand that's a better deal too, because you have less, you can have less claims if you have an arbitration program. It just seems a lot of plaintiffs' attorneys right now are saying, "Oh, do you have an arbitration agreement?" Yes. Okay, I'm not really interested in taking your case. The reason they're saying that is because they just don't know what the economic issues are for them in arbitration as opposed to their traditional litigation. That may change over time as more and more employers adopt arbitration programs, but right now it's becoming a wet blanket over litigation. On the plaintiff side, they kind of steer away from cases that have arbitration agreements in them. That may change. But, so given these benefits, a lot of employers ask a number of questions about, how do I have a program? Well, first of all, the nice thing is we now have, because of the amount of time involved, battle-tested arbitration agreements. We have a number of them that we prefer. And if you have a battle-tested arbitration agreement, what I mean by battle-tested, I mean it's been signed by employees, someone tried to contest it, the courts have enforced it. We use one that's been enforced by courts repeatedly, so we know we can point to the courts that adopted that. If you use a good vendor, and we currently recommend NAM, the National and Arbitration, what's they call it? I forget what NAM stands for. National Arbitration, and I forget what the M stands for. Do you remember, Matt? Mediation. National Arbitration Mediation Company.
Yeah.
I like NAM because of their prices, the rules are reasonable. AAA, American Arbitration Association, is pretty decent too. They're a little more complicated, but so far I really like NAM. Again, if you also do a good job on onboarding new employees with them signing an arbitration agreement and you keep those records, that is another good example of a good program. And again, you need to work with attorneys that have experience with arbitration. Again, some attorneys aren't comfortable with the speed of it. My background is I used to be assistant attorney general for the state of Ohio, and we would do a lot of cases involving employment disputes with the personal board of review. Quick process, very quick process, 10 days, hearing for a hearing officer decision. You have to get used to that speed these are fast. And if you have an attorney that's not, your attorney can actually slow the program down unintentionally or intentionally, and you lose a lot of the value of it. There have been some employers out there, again, arbitration is not new, it's been around, but the law that has changed has really pulled away a lot of the attacks on arbitration programs. That's the big change that occurred with the Epic decision. Some employers have created arbitration programs and just mention that there's an arbitration program in their employee handbook, and then have the employee sign that they reviewed and acknowledged the handbook. I am very opposed to that. I think that's not the right way to do it. Although some courts have enforced that. Again, what I'm talking about is your arbitration programs in your employee handbook, and the employee doesn't sign an agreement, but they sign that they reviewed, accepted the handbook. I think the best practice, because it is very solid, is you have a separate agreement signed by both the company and the employee. You can even have a provision in your employment hiring application that includes any disputes about hiring as an arbitration, which we recommend. But I suggest you have a separate agreement, and you also mention it in your handbook. But the employees will sign. Every employee will sign their own arbitration agreement with the company, and you keep a record of it. If you do that, I think it's a very solid program. So what should you include in an arbitration program? Well, there has to be some reference to what is the consideration. Again, this is good old-fashioned contract stuff. In order to have a contract between two parties, it can be verbal and writing. This one's going to be in writing, and it's going to be an offer and an acceptance, and something of value has to be exchanged, which is referred to as consideration. What's the value that you're giving the employee in exchange for them agreeing to this contract? In most states, as Amanda talked about, continued employment that is sufficient consideration for entering into a contract. But you should say that in your arbitration agreement. What is the consideration? In some of those other states that say continued employment is not, then you got to give something of value. A small payment, just something, additional leave, some other type of something else of value. It doesn't have to be a lot. It just has to be something. You should list what the claims are covered. Generally, you want almost all claims covered except workers' comp and unemployment benefits for a number of reasons. There were some employers, because of the concern about sexual harassment, during the Me Too movement, there were a lot of employees and advocacy groups that were arguing that employers trying to keep quiet sexual harassment issues in the workplace, and therefore creating these arbitration programs. And so they were carving out sexual harassment cases for their employees, saying that arbitration applies to everything but sexual harassment. That has kind of come and gone, so I don't see that as an issue, but you can list the claims that are included and those that are not, if you wish to. Don't recommend it other than workers' comp and unemployment. I recommend, but you don't have to have it, I recommend a pre-arbitration dispute process. Usually if you have an issue, you want to raise arbitration, you must write that out, give it to HR, let the HR try to address it first before we contact NAM or AAA to start the arbitration process. Again, I think those are good processes because you can resolve a lot of junk really quickly if you have those, and I've seen those successful. You get to choose the rules, again, within reason, if you know what you're doing. Each of these vendors, the key ones, AAA, NAM, and a few others, they give you the rules for employment and arbitration. But you don't have to accept those rules. You can go through them and reduce them, change them, delete them, modify them. And we have, with some of our arbitration agreements, we keep shorten the time frame, don't allow additional claims being brought after the initial one is brought, things like that. We sometimes remove discovery issues, can include or not include summary judgment, but you get to actually create those rules. You can also change the time frame, the statute of limitations within reason. This has been known for quite a while that you can take the legal statute of limitations and reduce it within reason in your arbitration provision. The claims have to be brought within 1 year of their event or things like that. But you can write that. We would recommend all your arbitration programs be mandatory, but because of the contract issues trying to get out of it, of duress, and there's an argument that some plaintiffs will make that, yes, I signed this arbitration agreement, but it's so one-sided that it's not valid, it's unconscionable. And one way to get around that is to simply allow an opt-out period that, we ask you to sign that, but you can opt out by taking certain steps. When we see that happen, we see very few opt-outs. And if they do opt out, that actually gives you a sign that an employee may be a problem for you down the road anyway. And then the other thing you can include, and you should include, is a class action waiver. I see no reason not to do that. That is a really big benefit. Now, those are not always common type of actions brought against employers, but when they do, they can be very expensive, and that one provision alone can be worth having the whole program. Other options to consider, do you want, when you create an agreement, again, we have several versions of our suggested arbitration agreement for different types of employers, and we go through this list. Do you want to include the plaintiff pay some of the costs? What we typically do is have them pay at least the typical filing fee that they would have to pay if they were going to bring their own lawsuit, either in state or federal court. That's usually a couple $100, but at least they have some skin in the game. You want to decide what vendor do you want. Do you want NAM or American Arbitration or some of the others? In theory, you can even create your own in-house one if you really know what you're doing. Do you want to permit preliminary injunctions? We usually carve that into or write that into the agreement because you may have a non-compete or you may have a trade secret violations and you want to get access to the court's ability to do an injunction very, very quickly. So we usually carve that out to allow preliminary injunctions for trade secret violations or non-compete issues. If you want pre-arbitration mediation, generally recommend that. Do you want to preclude new claims once once someone brings a claim for arbitration that they can't add new claims down the road? Do you want to carve out any claims? Like I said, in the past, they used to carve out sexual harassment. Don't recommend that now. Do you want to include a summary judgment process? Originally, I thought that was a good idea where you could ask the arbitrator to toss the case out if there is not a legitimate disputed fact, so you don't have to have a hearing. Now I realize that that's just not efficient. It's quicker just to do the hearing than to draft a motion for summary judgment. I think it's, what's the issue? Let's have some initial discovery, and let's show up for a hearing, and you put on your side, we'll put on ours, and you get a decision, and you're done. Try to do that within a 3-month process. We're done, and usually it's cheaper, better, and we got a resolution. We're all moving on. The case is solved. I love it. Going back to the traditional litigation in state or federal court, I can tell you over 30 years of practice that the process of employment litigation is brutal on plaintiffs. I've just seen it. A year and a half of litigation, depositions, arguments, hearings. It takes a toll on individual plaintiff employees, and it also takes a toll on employers who have to take a lot of time. Executives have to testify, discuss issues. It can be very brutal, and I think this process, getting an issue, a quick time frame, a hearing, and you're done, it's very cathartic for all involved. And I think it's just a more appropriate way to resolve disputes. That's why I'm really all in on arbitration. And today, it's not for everybody, but I think there's just so many benefits today for it. You can also decide whether you want to create an appeal process. If you're not comfortable with arbitrator making a decision, maybe you don't like it, there's no appeal process unless you write one in, and you can put in an appeal process like you would in any court to another arbitrator if you wish. But that is your option. But those are the options you can consider in writing your own program. And with that, I'm going to turn it over to Matt to wrap it up with how you should explain arbitration to employees.
Sure. Sam, you want to? So it's pretty straightforward, nothing rocket science here. Of course, the communications you're going to have will differ whether you're talking to a new hire or an existing employee. It's obviously easier to do this for a new hire because you can present the arbitration agreement to the individual at the time of hiring. We find that it's usually helpful to give them some reasonable explanation or a summary of the agreement and why the employer, you view it as a beneficial process to both sides. And you can require the individual to sign the agreement as a condition of employment. And as Sam mentioned, we usually do recommend having a certain period of time that allows them to opt out because that helps you show that they entered into the agreement voluntarily. But we find that most new hires, when they sign it, they don't go back subsequently and opt out of the agreement. But again, usually you're going to be most successful in getting them to sign it if you're transparent about what are the requirements and why you think it's more advantageous to both sides for resolving disputes. But when it comes to current employees, so Sam, I think you can look, is the some employers, the initial issue is do you roll out the program to just new hires or do you start rolling it out to your existing workforce? When it comes to the existing workforce, sometimes there's a concern about how might your current employees react if they are asked to sign an arbitration agreement. But again, we think that if you clearly explain the process, help them to understand what it will look like and what are the benefits, you're much more likely to have a much higher employee acceptance rate. And then the main issue when it comes to new employees, or to existing employees rather, is if they refuse to sign or they have any concerns. And so you want to decide how you're going to handle that. And really there are two options. You can let them continue on in their employment. If there is a legal dispute, then you're going to end up in court. Or probably the more drastic approach would be to separate their employment or to tell them that you're not going to put them on the schedule unless and until they sign it. But we think the better approach here, as Sam alluded to earlier, is just, again, to provide it, have them sign it, build into the arbitration agreement itself an opt-out period, which they have maybe 15 days, 30 days to consider the agreement further, and if they want to opt out or revoke the agreement, they can do so. But we find that, again, they typically don't opt out of it once signing it. And again, that makes the process seem a lot more voluntary than if they're left with the choice to either sign it or be subject to separation.
Yeah, with that, it's our brief discussion on it wasn't brief, but it's our discussion on arbitration. Like I said, I used to be kind of hostile to it, then skeptical of it. Now I am just a big fan of it. I just think it's a better way to resolve employment disputes for certain employers. And again, those employers that are sophisticated enough to know that the values of it, to have good record-keeping skills, and to at least have a sophisticated HR individual with the organization. If you have those three things, I think this is just the way to go these days, because we're just seeing better results and less problems when there's an arbitration than otherwise. If you have any questions, Matt and I would be happy to talk to you about this. You can always email me or just call, and then we Hope you enjoyed this presentation, and again, look forward to assisting you if you have further questions about this issue. Anything else, Matt?
No.
All right. Take care. Bye-bye.